Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today we're going to be talking to Andre Taylor, another one of Stein IP 2024 spring session interns. Andre, please tell us a little bit about yourself.
Hey, Michael. My name is Andre Taylor, and I'm really thankful to be on the podcast here with you today. I'm currently a student at American University, the Washington College of Law, as a third-year student. I'm currently interested in human rights and in international business, and I'm looking forward to being here with you today.
Okay, you talk about international business. I understand one of the research topics you did was on the International Trade Commission, or ITC. Why don't you tell us a little bit about what you learned about the ITC during your research and studies?
Yeah, so the ITC, otherwise known as the International Trade Commission, is a semi-judicial body that operates in the United States. It was created back in 1916 as a nonpartisan independent agency that has two main purposes. The first of which is to analyze various trade-related issues in the US and to advise the federal government, both the executive and legislative branches. And its second purpose is to conduct investigations related to imports and exports in the US. So it's a very comprehensive organization that has a pretty extensive purview. One of its most effective tools is its powers enabled under Section 337 of the Tariff Act of 1930, which is a law that essentially empowered them to conduct complaints and perform investigations related to misappropriation requests of trade secrets, as well as trademark and patent infringement investigations. So it's a very comprehensive organization that, with that Section 337, is able to conduct pretty extensive investigations of all types of bodies across the world, even companies that are performing operations extraterritorially.
That sounds like it does cover a lot. And I know they must have many decisions, many cases, but I believe we discussed and you conducted research into a particular case that is either before or was before the ITC. Can you tell us a bit more about that case?
Yeah, so during my time with Stein IP, I was able to investigate the Apple v. Massimo case, which is a very important ruling that was recently decided in the ITC and was a sprawling litigation that took place across multiple jurisdictions, both at the ITC as well as in federal district court. And that's one of the biggest cases that the ITC has heard, obviously, because of the scale of Apple as a company. And the basis of that case was essentially Massimo is a small health company that develops innovative technologies in blood oxygen sensor technology. And that's a technology that's become a lot more relevant in recent years due to the COVID pandemic. Blood oxygen is used to determine many things about people's health. So it became a very lucrative and useful technology to have across various sectors of US industry. And Massimo claimed that Apple was able to essentially poach various employees that they currently employed at Massimo or that they were employing at Massimo, and that they used the Massimo employees at Apple to develop their own blood oxygen sensor technology, which was integrated into the Apple Watch that they began I guess, making available to the public several years ago. And Apple was in turn claiming that they found that they hired the Massimo employees, but that they fired them relatively quickly and that they began production of the new Apple Watches well after they had already fired the Massimo employees. So there was a bit of an impasse here where Massimo was claiming that because of the work that their employees had done with Apple, that essentially the Apple patents were in violation of Massimo's own patents. And so the case was, like I said, very sprawling, and the ITC eventually got involved. And in the ITC, Massimo was seeking an injunction that would essentially prevent Apple from being able to import several of their Apple Watches. It's like it was the Apple 6, 7, 8, and I believe also the 9. So all of those they intended on preventing from being imported into the United States. And
That must
ultimately,
have, but that must have a significant impact. I mean, I've got my Apple Watch, and I know millions of people, and so you started to say, ultimately, yeah. One of my next questions was going to be, where do things stand in that case? And did Apple have to do anything, damages, or I guess in the ITC they don't even permit damages. So, what what happened?
Exactly. So one of the main tools of the ITC is the ability to issue injunction orders, and that prevents the respondent from being able to provide or being able to import any of their goods or affected products into the United States. So as you can imagine, like you were saying, that's a huge ramification for a company like Apple, which does the majority of its production overseas, which creates a very huge issue for their own profit margins and for potential partners that they're involved with. So ultimately, what happened is that the ITC ruled that Apple was in violation of two claims of a fifth patent. So they didn't clarify that all of Apple's patents were in violation of Masimo's, but that at least one of them was. And the end result was that Apple did place a temporary ban on various watches that Apple is currently making. So the Apple 6, 7, 8, and 9 watches were all prevented from entering the United States. And because the president had the ability to stay the order and prevent the order from actually coming into effect, but he chose not to do so, that order eventually went into effect and Apple was prevented from being able to import their items. However, what Apple did in order to work around that issue was by modifying the Apple Watches so that it didn't incorporate the blood oxygen sensor technology. And what that did was it prevented that they were essentially now in compliance with the order when with the injunction. So because they no longer were producing the blood oxygen technology, they were now able to import the Apple Watches without that feature into the United
So
States. So yeah.
did the ITC approve of the workaround, or do you know what the answer to that?
Yeah, so the ITC has not issued a direct statement on Apple's actions, but they haven't clarified that they're in violation of the injunction as of right now, because the basis was that they had the blood oxygen sensor technology in the Apple Watches, but because that's no longer the case, Apple's able to freely import them at their own leisure.
And from what I read, even after the initial ITC hearing, the president has the authority to wipe out the decision, or how's the president involved in any of this, if at all?
Yeah, so the ITC has the ability to issue injunctions, but the president does have the ability via his own executive power to prevent those orders from coming into effect. So the president had a brief window where he was able to prevent the order from coming into effect, which would have allowed Apple to bring in their various Apple Watches with the blood sensor technology, but they declined to do so for various reasons, and ultimately the Apple Watches were prevented from coming in.
Okay, sounds like at least somewhat nice victory for Massimo over Apple, and it seems like
Absolutely.
the ITC was a good route to go in this case.
Absolutely. Yeah, the ITC is a forum that's gained a lot more popularity in recent years for a lot of smaller tech developers and just smaller businesses in general. In fact, from 2017 to 2021, they've seen a massive explosion in the number of investigations that they're doing under Section 337. So it went from one investigation to well over like nine, I think. So it's been an over 800% increase in the number of cases that they're currently involved in as far as investigations. So it's a very powerful and influential forum that I think a lot of companies are seeing value in as far as being able to potentially engage in violation infringements against other companies and being able to hold them accountable for violations of their IP.
From my understanding is the timeline is actually pretty rapid. I don't know if you came across that in your research, but another advantage of the ITC over district court, let's say, is that things have to happen within a confined time limitations.
Yeah, so the ITC does provide rulings, and the rulings can create difficulties as far as timing for the respondents. But I'm not aware specifically of anything that was related to the Apple versus Massimo case. I do understand that it was a very expedited timeline. So when the ITC issued its initial injunction against Apple, the president only had a couple weeks to issue a stay on that order, but ultimately that didn't happen. So it's a very quick timeline, and it obviously would, I imagine, involve considerations that maybe go beyond the legal sphere. But yeah, so timing can definitely be an issue, but companies are always going to be aware of that and cognizant of how to approach that issue.
Well, Andre, thank you so much for giving us your insight into what you've learned. And thank you for being a spring 2024 intern here, and wish you all the best. I believe that you're going to be taking the bar exam come July. Is that true?
Yes, I'm going to be taking the bar this coming late July, so I'm looking forward to that and getting studying.
Looking forward to that, or looking forward to passing and getting beyond that, I assume.
Looking forward to passing it, clearly. Yeah.
Right. Okay. Well, audience, thank you very much for tuning into this episode of Unraveling Intellectual Property with Michael Stein. I'm sure that we'll have future episodes where we'll go into greater detail on the workings and the processes of the ITC. So tune in, subscribe to our YouTube channel, and see you soon.